My lord, in fact, the institute had made a recruitment of associate professors in which certain qualification mandatory and experience was also called for. The grievance of the petitioner herein also at that time that the institute had appointed certain persons who were not having the experience for working on a particular pay band post.
That was already accepted by the appellant.
Let me complete. Now, it was not our...
Mr. Srivastava, let her make submission, you can answer. Yes.
Thank you so much, sir. Sir, if we look at page number 20.
Be short.
Yes, sir. I will try to be
Otherwise
extremely
you
short.
won't be able to conclude
yes,
it,
yes,
sir.
Yes, sir. So, sir, in their appeal, in page number 25, list of information which I requested for is there. And the only two information which was discussed or which was requested in the impugned judgment was point number 2, that is enquiry report, and point number 5, that is the copy of application for the post of associate professor. So I'll first would prefer to take up with reference to copy of application for the post of associate professor and this. My lord, as we can see that this is the entire information which I have asked for. These information were used by the institution. First is to evaluate whether these two candidates are eligible as per the statutory eligibility norms or not, and at the same time these documents were also used to evaluate these two candidates in comparison to other candidates who appeared in for interview. So as we know that this recruitment, it is perfectly a public activity. However, they have denied this particular information, saying it is 81J, which is a personal information, and quoting that the third party has denied. So the question before us is that this information which is related to the recruitment, can it be denied under section 81J? So now to look at that, what exactly section 81J says. So in my reply, my lord, I request you to kindly go to page number 79 in my reply, where I have attached some of the relevant sections of RTI Act. Page number 79, R1. Shall I read, sir?
Begins with point 76.
R1, page number 79, in my reply, sir.
R1, reply.
R1.
In the writ court.
Yes, sir. The file number is 12487/2025.
What page of your reply?
Okay, so
what page number of your reply?
Page number 79.
Begins with provided that the decision.
Yes, sir. Yes, sir. Yes. So I will read from the third para, which is J. So this is 81J. So if I read this, they have referred to this. They have refused using section 81J. Which is one of the exemptions. So if we read this, information which relates to personal information, the disclosure of which has no relationship to any public activity or interest. Now, if we actually look at this, my lord, this RTI Act, it basically divides the personal information into two parts. One is the personal information which has no relationship to public activity and is not of interest to public, and the second is personal information which has a relationship with the public activity and is of public interest. Out of these two categories, the information which was used for public activity, that does not get exempted under section 81J, and therefore applying section, they have refused, saying it is a personal information, but they missed to see that this is the personal information which has complete association with public activity, which is a recruitment, and naturally it is of public interest because this is a recruitment thing, and therefore they applied 81J wrongly. Again, if we look at the para below this particular para, my lord, I am reading it, provided, but it starts from provided that the information which cannot be denied to Parliament or a state legislature shall not be denied to any person. So again, my lord, this is a bigger question, that can the information related to the educational qualification or experience or any other things which are required to check whether the candidate fulfills the statutory qualification requirement or not, I'm sure that that cannot be denied to Parliament. If we look at some of the cases related to recently, one of the IS officers was found to be ineligible because she used a medical record as per which she was not eligible to get a disability category, and she used NCOBC again, where she was not qualified under that particular category. All these information was gathered through RTI, and that only resulted into a final conclusion that she was not eligible. And it is not just this, my lord, there are so many cases. If we take case of director of IIM Rohtak, recently there was a case of College of Excellence of I in Indore. In my own case, where the Pratik Maheshwari was found to be ineligible, the documents were acquired through RTI. So unless we get to know that whether the person is qualified or not, how we can conclude that the person, whether to make him continue in the job or not. Now, if we look at section 11, they are also saying that section 11, that third party has denied. Now, section 11, which is there in the same page, my lord, from the last line, second last line, my lord, 11, third party information. So again, section 11 is used when CPIO intends to give the data of third party. So he is supposed to check from third party whether the data should be disclosed or not. And if the third party denies, under that condition, it cannot be considered as a ground for complete denial. CPIO is supposed to evaluate the importance of that particular data from the public point of view. And I'm sure, my lord, CPIO and FAA, everyone knows very well that if it is a data related to the person whom they have appointed, and if the person is ineligible, then naturally the salary, you are paying salary to the person. Salary is a matter of, or the matter of salary is statutory in nature. Salary cannot be paid to any ineligible candidate. Students have a right, that this again is a fundamental right of students to get taught by eligible faculty members. And therefore, again, if the candidates are ineligible, we cannot make them to teach to students. Not just this, IFM being not just an academic institution, but it takes in various types of research and consultancies also from Government of India. And all these people, all the faculty members, they get involved in research and consultancy, which is funded by Government of India. Can we allow ineligible person to perform all such type of things, my lord? So there is a complete association with public interest. And apart from this, what section 81J says, I have enclosed multiple court cases, my lord. These court cases which I have attached over here, these court cases are different from the 3 cases, in fact 4 cases which I attached during the previous hearings of the impugned judgment. So when it comes to court cases, my lord, I request you to kindly go to page number 85.
Yes.
Right. So, sir, this is a court case from fourth line, point number 9, fourth line of point number 9, which starts from it is in. There is no educational qualification prescribed for contesting any electoral position under the law. The election to Lok Sabha or Prime Ministership cannot be questioned on the point of educational qualification. Where there is a prescribed educational qualification for a position and its existence was doubted, its disclosure will be in public interest. That is not the point in this case. My lord, this is a case of where the degree certificate of Honorable Prime Minister was asked, which was denied in this particular case. However, this was the statement made by Honorable Gujarat High Court. And in this case also, as over here, they have written that if its existence was doubted, in this particular case, my lord, the existence is extremely doubtful, because what had happened in this particular case is that
Delhi High Court has recently said it can't be shared.
Sir, there are no, sir, I know about that case. I know about that case. Delhi High Court refused.
You have the judgment.
Delhi High Court, sir, वो judgment जो था वो बाद में आया था. That was also related to Honorable Prime Minister and श्रीमती स्मृति ईरानी.
You have the judgment.
सर वो जब यहाँ मैं उसके पॉइंट पढ़ती हूँ सर, मैंने यहाँ पे लिख के रखा हुआ है, वो वाला जजमेंट जब मैंने इसको सबमिट कर दिया था उसके बाद आया था. In that case also, मेरे यहाँ पे साइड में लिखा हुआ है, I'm just reading the point from that. The situation would have been different if the educational qualification had been a prerequisite for the eligibility of a specified public office. This was the statement made by Honorable Delhi High Court while refusing the degree certificate of Honorable Prime Minister and 10th and 12th certificate of Srimati Smriti Irani. In this case, my lord, if we look at if its existence was doubted, so I would like to bring to your notice that in this case, in this entire recruitment case, what had happened is that the screening committee did a wrong screening. They did screening ignoring the statutory criteria. And when something has gone wrong in the process, my lord, naturally all the output has to be checked. And there were only 7 candidates who were appointed on in that particular recruitment process. One of the candidates was already found to be ineligible. One candidate denied to join. Out of 7, 2 had gone. Then remaining 5, 3 were from IIFM faculty members only, who got promoted to the higher position by participating in that recruitment process. Remaining are only these 3 things. In that particular, and that is a report which was submitted by none other than the appellant institution to CIC, where they have confessed that a screening committee did a wrong screening. They ignored the MOHRD criteria. And one of the points which they have stated, if you want, I can take you to that report which I have attached here. And one of the criteria which mentioned is that in case of Pratik Maheshwari, they counted his experience in 2 private institutions, which they should not have done as per MOHRD norms. And these 2 candidates, about whom I have requested for the information, these 2 candidates are also from the private institutions. So that is the reason that the doubt is too high. If you remember, my lord, in last time I said 99% chances are there that they are ineligible. They are serving for more than 4 years. And now if I will take you to one more, in fact 2 more cases. One is of Honorable Mumbai High Court, which is in very next page, page number 87. Shall I read, my lord? Right. So the major point starts from page number 88. Okay, shall I read? Okay, right. So page number 88, if we read point number 5, that what is it which was actually asked, the marks secured by the petitioner in screening test, Marathi typing test, English test, in recruitment process. Now I will only read very important points, my lord. For that, I request you to kindly go to page number 91.
insofar as the officers are concerned, they've now been removed.
Which officers, sir?
Your application, RTI application, was against one Dr. Pratik.
In fact, he left.
He is not there.
He's not there.
So what survives?
Pardon, sir?
What survives now?
The other two candidates who are likely
Who
to
are
be
the other two candidates?
about whom I have requested for
Okay.
information in point number 5.
Where are they working now?
They are working in IAFM
As what?
as associate professor.
And what about you?
I am also working in IAFM.
So what do you want now?
I want
Them to be removed so that you are the only person eligible for everything.
No. They are
Why
from
are you targeting your colleagues?
My lord, they are the very important thing is, if somebody is ineligible, Supreme Court says that it is fraud on public to appoint a person with inferior qualification.
That's all right. The department will look at it.
Department is not looking. Department is protecting them.
Is this a public interest litigation that you have?
No, this is not a public interest
You want
litigation.
the salary paid to them so that can be recovered? You can't understand
My
what
lord,
is
this in fact, I asked earlier, as I said, naturally, DOPT norms and CCS rules, it clearly says that if somebody is responsible for misuse or of public exchequer, the money has to be recovered. तो क्या सर ineligible लोगों को हम survive करते देखें? ये सर मेरा institute है. I am working in this institute since 2010. I cannot see any ineligibility survive in this particular institute. Sir, IFM ने बहुत मेहनत करके जो भी अभी IFM की जो इज्जत है वो बहुत मेहनत करके कमाई है. अगर कोई बीच में आता है और वो इस तरह से illegal लोगों को I will not say illegal until unless I have their certificates. अगर ये लोग survive करते हैं sir, it would be a fraud on public. Sir, I will take you. Sir, next.
What is the? We'll consider it. We'll put it down for hearing.
Sir, there is this Mumbai High Court, and this was challenged in.
Miss
Jayashree
Dubey, it requires consideration. Requires a detailed hearing. We'll put it on for hearing in the final list.
Sir, so just allow me two more cases, sir. This only Mumbai High Court, and which was challenged in.
It requires hearing. We are not rejecting your argument. We'll take some time.
Sir, 2 more minutes, sir.
No, but then we have to hear them.
Sir, just 2 more
All right,
minutes.
you have
sir.
your 2 minutes.
Okay, sir.
Please go ahead.
Right, sir. So this is the other case which I've mentioned over here. In this case also, this is a Mumbai High Court case where the judgment was given on November 2024. Here also, the details related to the selected candidates were asked. If we go to page number 91, my lord, point number 27, it reads that in this case we are concerned with the selection process for the post of .. Essentially, this is a process by which applications were invited for all eligible candidates by issuing public advertisement. In that sense, public process must be transparent and above board. The marks obtained by the candidate in a selection process cannot ordinarily be held to be personal information, the disclosure of which has no relationship to any public activity. I am also reading point number 28, my lord. The legislature has not exempted all personal information under section 81J, but only such personal information, the disclosure of which has no relationship to public activity or interest. My lord, the information which I asked for are the information which were referred in recruitment, which is a public activity. Then I would again like to continue in page number with page number 92. The process amounts to personal information, the disclosure of which has no relationship to any public activity or interest. Given that selection process must be transparent and above board, it would be in public interest to disclose such information rather than withhold it and allow any doubts to linger upon. Now, in this case, they have made reference to the judgment of Honorable Supreme Court in page number 94, point number 38. Sir, I will just read this and SLP. Page number 94, point number 38. Recently, in Tej Pratap versus Rajasthan High Court, appeal number .. the Honorable Supreme Court stressed upon transparency in public recruitment process. The Institute of Chartered Accountant of India versus dash dash dash, the Honorable Supreme Court highlighted the RTI's objective to ensure transparency and accountability and urged examining body to adapt to a new disclosure regime. Thus, the trend under RTI regime to disclose the information that would maintain trust in the recruitment process without unduly compromising the privacy of any candidate. A distinction must be made between sensitive personal information like medical details, etc., and information intrinsically linked to the marks obtained, qualification, and experience of candidate. So, my lord, these are the statements from the Honorable Supreme Court. In this case, Honorable Mumbai High Court allowed the disclosure or sharing of information. This particular decision was challenged in Honorable Supreme Court, and which the SLP was rejected, and I have attached this in page number 99. While rejecting this SLP, the observation of Honorable Supreme Court is given in page number 100, my lord.
Yes.
I am reading from the 4th line. The issue relates to the disclosure of marks of other candidate in the examination. We are also of the view that the disclosure of the marks, though may fall in the category of personal information, yet the disclosure of the personal information is presently necessary in public interest, and therefore it is not an information which cannot be given by the information officer under RTI Act. To the contrary, such information must be disclosed in order to maintain transparency in the process. Now, this is an observation of Honorable Supreme Court, my lord, and I believe we have all the reasons based on Article 141, we have all the reasons to not to interfere with the decision in the impugned judgment. There are so many other things, my lord. I have attached 3 cases of CIC, one larger case.
That's all?
So there are so many other things. I mean,
you see, admission matters we're concerned with. Students wanting admission, we're more concerned with those matters than this. They don't list
so
for,
we can, in fact, on this,
list for
there are
week commencing 19 January. Interim order to continue.
Sir, kindly place it in 3rd week. I'm due for knees replacement surgery.
Sorry? When do you want it?
Sir, 3rd week of January.
3rd week of?
January.
So 19th January is 3rd week of January?
Yeah, for, ji sir.
19th of January?
19th January.
19th.
Week commencing 19th January.
My lord, may I make a request? My lord, item number 49 also arises from the same order which is under challenge in this. My lord, that
You are appearing for whom?
My lord, appellant in that case. My lord, who?
The private
my lord.
professors?
No, my lord. My lord,
The information.
All right, along with this then.
sir, in fact, this petition is illegal. It is not maintainable, sir. It is against RTI Act.
Yeah,
It
we'll
is against
consider
government
that.
OM.
Item
It is
number?
against judicial
49,
precedents.
31 and 49 say list for consideration week commencing so and so. Interim
Let
order.
it be in the final hearing list.
Sorry?
So that at length matter can be addressed to.
Sorry?
This matter can be listed in the final hearing part so that matter
Yes.
can be,
I'm
because she is
perfectly,
not giving up everything.
Sir, no, what do you mean? I am not giving up anything.
So may I make a submission and brief to,
Mr. Srivastava, we have other matters to look at. This is not that urgent a matter. We'll see week commencing 19 January, then we'll